right. So welcome everybody to American University and PIJIP's continuing Supreme Court series, wherein we look at a Supreme Court case that deals with IP, and we hopefully have the representatives of the case that argued that case the day of the case to come to us and talk about the case. Today we have the privilege of having two firms representing the clients in the room. So we have a very distinguished panel today. We have 6 members of the panel. I will introduce them all, and I will give a brief summary of what the case is about. Then I'll turn it over to them to discuss what the arguments were and why the case is important. So let me start, quickly walk through the panelists today. So first of all, we have Mark Perry of Gibson Dunn. He was the representative for Smith and Nephew in this case. He clerked for both Justice Sandra Day O'Connor and Judge Alex Kaczynski and has made multiple appearances before the Supreme Court, including this morning. Perry is the co-chair of Gibson Dunn's nationwide appellate and constitutional law practice group, notably argued for CLS Bank in its landmark case against Alice Corporation. He graduated from the University of Chicago Law School and has spent more than 20 years at Gibson Dunn. On their side, Robert Cry is representing Arthrex in this case. Mr. Cry is a founding partner of Molo Lampkin, which he joined after several years in the Supreme Court and Appeals practice group of another prominent law firm. Before that, Mr. Cry served as a law clerk to Justice Antonin Scalia of the United States Supreme Court, and he too served as the clerk for Judge Alex Kaczynski of the United States Court of Appeals for the Ninth Circuit. So we have 2 Judge Kaczynski clerks joining us today, and he is a graduate of Yale Law School. Then we have Steve Vladeck, who holds the Charles Allen Wright Chair in Federal Courts at the University of Texas Law School. He's a nationally recognized expert on federal courts, constitutional law, national security, and military justice. Prior to joining the University of Texas, Steve was a professor at American. We were colleagues, and he was one of the 2 best basketball playing professors on the faculty. Professor Vladeck has argued before the Supreme Court, and he is CNN's Supreme Court analyst and submitted an amicus brief in this case on behalf of Intel Corporation in favor of Smith and Nephew's position. Greg Dolan is an associate professor of law on leave at the University of Baltimore Law School. Perhaps the only job that's cooler than a law professor is that of a justice of the Republic of Palau Supreme Court. Greg holds both those job titles. Greg clerked for Judge Pauline Newman of the U.S. Court of Appeals for the Federal Circuit, and he submitted a brief on behalf of the Cato Institute in favor of Arthrex position. Melissa Wasserman is the Charles Tilford McCormick Professor of Law at the University of Texas Law School. Her research focuses on the institutional design of innovation policy with a particular emphasis on patent law and administrative law. She clerked for Judge Kimberly Moore of the Federal Circuit, and full disclosure, Melissa and Greg and I clerked at the Federal Circuit during the same year. And last but not least is John Duffy. John Duffy is the Samuel H. McCoy II Professor of Law and the Paul G. Mahoney Research Professor of Law at the University of Virginia Law School. Professor Duffy teaches and writes about patent law and administrative law. Professor Duffy clerked for Judge Stephen Williams on the DC Circuit and for U.S. Supreme Court for Justice Antonin Scalia. And he is also an undergraduate physics major, as are many great law professors. So thanks the entire panel for joining me. And I want to turn over to Mark Perry. Well, let me just, before that, we have some students in the room. So let me talk about the case briefly for 1 minute, then I'll turn it over to Mark Perry. So in this case, we have a dispute between Arthrex and Smith and Nephew. And their basic dispute is about the status of administrative patent judges. And administrative patent judges are something that was created by statute in 2013 at the United States Patent and Trademark Office. They sit on the Patent Trial and Appeals Board. So if you are challenging a patent in inter partes review, for example, you take the patent to the patent PTAB, and you have 3 APJs that hear your case. Today, the case is basically about what is the status of the position of APJs. So there are 2 main issues. They're discussing what the status is of the APJs. The first issue, and the main issue, I think, is whether administrative patent judges have been acting as principal officers of the government, or if they are inferior officers of the government. Now, this may not seem like a big deal, but it makes a huge difference. Principal officers must be appointed by the president and confirmed by the Senate, which has not been the case with APJs. Alternatively, if the APJs are inferior officers, they can be appointed by heads of departments rather than by the president and the Senate. So the Federal Circuit heard this case in October 2019, well, decided the case in October 2019, and they decided that the APJs are superior officers. They didn't have enough oversight to be considered inferior officers, and therefore they were superior officers and principal officers, and therefore unconstitutionally appointed. But the court also found that they fixed the problem by severing a part of the Patent Act that made APJs difficult to fire, thus converting them to inferior officers. So this decision led to this kind of difficult to discern 3-way appeal, cross appeal, with the government and Smith and Nephew disputing the Appointments Clause decision, and Arthrex fighting the remedy crafted by the Federal Circuit. So with that, I will turn it over to Mark to walk us through what his side is arguing in the case and why he thinks his side is correct.
Thank you, Jonas. And I'm not going to re-argue it. We had it's on tape or something. Somebody can listen to it, or you sent around the transcript.
Yep.
This case is for one thing, from the private practitioner's perspective, right, is fascinating. We don't always get the opportunity to dig in and mess around with the guts of the Constitution, and here is a case that is involved, as was the Lucia case that I argued a few years ago, which involved the SEC ALJs, and it's a fun reminder that in the commercial world, the Constitution continues to have significance, and here's another example of that intersection of law, or constitutional law, and commerce. Our challenge, I think, in taking it up to the Supreme Court was, first, showing that the Federal Circuit got it wrong. We were assisted in that by the fact that nobody actually defends the Federal Circuit's decision. So we have an interesting proposition that we have a case in the Supreme Court with 3 party briefs and 31 amicus briefs, and not one of them adopts or defends the rationale of the lower court. And in fact, the entire case in the Supreme Court, the entire theory of constitutional law being presented to the Supreme Court, has never been litigated in any court and has never been accepted by any judge in the history of the Republic. So we have a brand new theory, never before litigated, being presented for the first time to the Supreme Court, which is not the usual way things happen in the Supreme Court, actually. This is not a complaint, by the way. This is kind of fun to have it come up this way. So that by the time the case gets to the Supreme Court, now the theory is administrative adjudicators must be reviewed by superior executive officers, apparently unilaterally and apparently in every decision, according to Arthrex. And our challenge is to say that that's not required by the Constitution. And one might have thought, I certainly would have thought, that the Appointments Clause of its own nature, of its own volition, and certainly the precedence of 232 years, have never suggested that there are specific procedural requirements that determine the difference between an inferior and a principal officer. But that theory got a fair bit of traction today, as all of you have seen, or anybody who read the transcript will have seen. And it is going to be very interesting, I predict, to see how the justices reconcile the many strands of originalism, of novelty, of deference, and of this sort of underlying whiff of due process that is floating about the appointments clause, and whether or not those are two separate strands or whether they come together. And it strikes me in listening to the questions and thinking about where the court might go that we are at a crossroads of the appointments clause jurisprudence. The court could sort of truck along the way it always has, which is with these fairly Delphic standards with the pronouncement at the end of the case as to what happens. Or the court could do something different. Arthrex's position largely invites the court to inject a judicially enforceable procedural component to the appointments clause that would have ripple effects throughout the federal government, and whether or not that matters. So without belaboring the point, my goal was to rest on the traditions of the patent office, the fact, and it is a fact that no one more than one step removed from the president has ever been held to be a principal officer. It has been conjectured that some people might be. Justice Scalia allowed for the possibility, of course, but the court has never so held. And here we have people that are 3 steps away, and hoping to draw to a majority some combination of justices that will have a pragmatic approach to the appointments clause issue in the administrative state, as well as a sufficiently originalist and precedent-based standard to justify that. We will see. We will see.
Great. Let me turn it over to Robert Cry on the other side. He is of the firm that represented Arthrex. And what is the thrust of the argument behind Arthrex's position in this case?
Well, thank you, Jonas. Mark says that the argument being pressed in the Supreme Court is novel, and I'd respond that if the argument's novel, it's only because what Congress did here is so anomalous, judged against historical standards. Since the start of the Republic, really the standard federal model for how agencies are organized is that often you have initial administrative judges that have tenure protections deciding cases in the first instance, but then you achieve accountability by giving the heads of the agencies the power to review those decisions. And so that allows you to have accountable decision makers with a transparent process for reviewing those decisions. The PTAB is really anomalous because what it has initial decision makers, but their decisions are not reviewable by the head of the agency. You can only seek review of those decisions in court, or seek review and rehearing of those decisions by the same board that decided them in the first place. And that, judged by historical standards, is quite an anomalous structure. And I think that was acknowledged repeatedly by even the justices that may have had some reluctance over our position. The reason for that traditional structure is not hard to imagine. When you have an administrative judge, what they do, the way they exercise executive power is by deciding cases. And so if you allow them to issue those decisions, but don't give any superior officer any ability to correct or modify those decisions, how can you claim that they're acting as inferior officers subject to direction and supervision? And so Arthrex's case from the outset has been that for this particular category of officers, administrative judges, Congress can't completely eliminate the power of principal officers to review their decisions, but nonetheless maintain that they are still inferior officers. And as Mark suggested, I do think that that position found quite a bit of favor on the court today. That's only one of the two issues, though, because the other issue is remedy. And Mark's absolutely correct that nobody in the court today was seriously defending the Federal Circuit's remedy. The Federal Circuit thought the way to fix this problem was to eliminate the tenure protections that administrative judges in the Patent Office have, thus creating a system where both you don't have impartial adjudicators at the first level, but then on top of that, you don't have an accountable, transparent review structure where the agency head can oversee those decisions. So it sort of eliminates the benefits of both aspects of the traditional federal model. Neither party was defending that, and certainly no justice at the Supreme Court seems seriously interested in affirming the Federal Circuit's remedy. There was some disagreement over in the court about how to proceed. Some justices suggested that maybe the way to do this was to sever a different provision of the statute instead of the tenure protections. And one example that was floated was whether there was a way to judicially sever the statute so that the head of the agency could single-handedly review APJ decisions. The other approach was to allow Congress to decide. And I would suggest that that latter one is the better reasoned view in these circumstances. First of all, it's actually really, really difficult to figure out a way to sever the statute that actually achieves director review. There's a provision that says only the board can grant rehearing of a decision, but just getting rid of that provision doesn't actually give the director the authority to rehear decisions, both because then the statute would just be silent, which means the board would still be the one with the power of rehearing, but also because even if the director has the power to grant rehearing, the rehearings themselves are still conducted by the board, which are made up of 3 members, unless you also hold unconstitutional that provision. And so by that point, you're really doing some very serious surgery on this statute. But even apart from whether you can do it, there's just very grave doubts that this is what Congress would have wanted. On the one hand, administrative patent judges and their predecessors for 114 years were appointed the way principal officers are appointed, by the president with confirmation of the Senate. On the other hand, Congress last year responded to this problem for the Trademark Trial and Appeal Board by giving the head of the office the power of review. So we see very conflicting decisions about what Congress would want to do here. Ultimately, those are policy decisions. And so it's really up to Congress to decide. And I think Justice Barrett was the most clear on this, that in this kind of situation, courts really shouldn't be undertaking the judicial policymaking that would be involved in picking those options and then trying to rewrite the statute to accomplish their best guess about what Congress would want to do.
Great. So let me turn over to the panel. I want to get just your what you thought happened today, what you're surprised about, anything from today's argument that caught your eye or surprised you that you didn't expect.
Well, I'll go if no one else is going to jump into the fray.
Go for it.
I think that the one thing that I did kind of expect, but I didn't expect it to play as much of a role, it was the discussion of sort of the Rube Goldberg machine-like argument that the government has that, well, you can control these judges by, granting rehearing, and then the director can sit on that and sort of strong arm a majority into doing his view, and maybe also publish guidelines at the same time that have a hypothetical that sounds exactly like this case and show how the outcome would be. And I think that the Chief Justice sort of summarized that sort of congeries of systems and said, this sounds like a charade of an adjudication. Now, I sort of expected that because in the oral argument of the oil states case, which was another constitutional case involving the sort of constitutionality of this board as a whole, not on the appointments clause, but on other separation of powers grounds, the Chief Justice had singled out one mechanism that the government has sort of said could be used, which is stacking the panels. In other words, adding judges, sort of the director sort of inserting judges into these panels to try to get the result that he or she wants. And the Chief Justice said, well, does that violate due process? And he asked this question of the government, and the government said, well, it only happened in, 2 times or maybe 3 times. And the Chief Justice cuts off the government immediately back in this other argument and says, let me rephrase the question. Did it violate the Constitution on those 2 or 3 times? In other words, the government, the Chief Justice seemed actually angry that this had happened at all. And it's a sort of set of mechanisms that the Justice Department and the government is relying on, that all have a sort of sleight of hand character to them, that I think the Chief Justice finds all of those sort of individually, he has some difficulty with them, and together he thinks that they just don't fly, that they create a charade of adjudication. And I think that was a good summary of the sort of arguments that the government had to sort of control this panel that has no sort of immediate obvious control. And the Chief Justice, one last thing I'd say is the Chief Justice is also good with a turn of phrase. I think he also said that there's really, there's not a system of clear control here. And one of the goals of the appointments clause that the court has said in its earlier case law, and that the framers were concerned with, is a bureaucracy where lines of responsibility are unclear. And this whole set of, well, the director could maybe do this and maybe do that, leads to exactly sort of the Madisonian nightmare of there not being clear lines of responsibility within a branch of government, so that each party can point to the other and say, well, he really did it or she really did it. And nobody really knows who is at the end responsible for the action, for the agency's action.
So, I mean, I guess I'll pick up there, because I mean, I think John's comments, which I think are a very fair summary of the argument, are also a big part of what I found frustrating about today's argument, which is that, I think what we're seeing is the culmination of a decades-long project led by conservative justices to turn the appointments clause issue into an incredibly formalistic, bright line test, the likes of which we've never seen before. And so, there were a number of colloquies today where justices asked, Deputy Solicitor General Stewart and Mark, well, where's the line between, the principal officer and inferior officer, when the court itself had been clear for a very long time that it's not an easy line to draw under the court's own precedents. And, my exasperation as someone who has studied and briefed this issue from the perspective of military judges after Edmund, and not just as counsel for the cross-industry parties in this case, is that unless Edmund meant to overrule all of the court's prior appointments clause cases, which it specifically said it was not doing, then the notion that control is the sine qua non of the appointments clause analysis, I think is a very, very stilted reading of the court's jurisprudence. I mean, just to take the point numerically, as of the end of last fiscal year, there are 221 APJs. That's more than 40 more APJs than there are circuit judges. The implications of suggesting that control is going to be the watchword for all analyses of who's a principal and inferior officer means we're going to have thousands and thousands of principal officers. And maybe there are people who like that idea, maybe there are people who don't like that idea. I just think that it's not, if we're talking about what is and what is not, consistent with historical practice, I mean, thinking that there are that many principal officers in the federal government, I think would be a pretty big surprise to a whole lot of people.
Yeah, I'll just jump in too. From my watching the Supreme Court is normally from patent law, and it's interesting to see the court and how formalistic they are in these sort of appointment clause, from watching over and over again them sort of overturn the Federal Circuit's bright line rules with respect to substantive patent law, and then to see here where so much of it was focused on does the director have review, right? And even as Steve is saying, the control, right, it's a very specific type of control. It's director review, right, over PTAB. So I knew that would definitely be part of the important part, right? But I was a little surprised, I thought, about how much of it seemed to turn on that, and that this idea of it's really important for transparency or accountability, right? This idea that even if we give it and they just delegate it and things stay the same way, right? That's fine, because now you have you can point to the director and say, you're still accountable. It just seemed somewhat like legal fiction, right? That was that important with the formalism of the argument today.
And I mean, and it's not for nothing, right? I mean, I think we also saw today, and I'd be curious if the other folks agree. I think we really saw today what the change in composition of the court means for these kinds of questions. I mean, it wasn't so long ago that we had two firmly entrenched 4-justice blocks when it came to whether to be formalists when it comes to the appointments clause and these kinds of separation of powers questions, and Justice Kennedy sort of chilling in the middle. And I think, you know, everyone understands that Justice Kavanaugh is a very formalistic when I mean, his DC Circuit opinions and intercollegiate in sound exchange, you know, I think speak for themselves. And I think we also saw that Justice Barrett is very much of the same ilk, which means that instead of it being, you know, a close call, there are probably now 6 formalists on this issue. And I think that's going to, you know, whatever that augurs for the result here, although I think it's fairly clear from the argument which way the court's going, that's going to have pretty big ramifications far beyond patent law. I mean, I think that's going to have, you know, as I think Justice Breyer tried to get at in a couple of his questions today, that's going to have pretty significant consequences for administrative law much more generally, especially if we start comparing other ALJs to APJs.
So let me jump in here and kind of I don't disagree with Steve and Melissa that the court is taking a quite formalistic approach, but they say it like it's a bad thing. And it's not obvious to me that it is. I think part of the problem, part of the reason why this case came up is because the sort of this multifactorial amorphous test is not easy to apply. It doesn't give us sufficient guidance either to lower courts or to Congress. It's kind of, I think there was a Justice Alito's question who kind of said like, well, what if I take away this factor or that factor or this factor or these 3 factors or maybe these 2, but not that one? Where is the line? And and of course, and I respect the answer that I suppose Steve would give, saying that, look, I can't tell you ahead of time, but it's sort of perhaps it's a kind of I know it when I see it. It is tell you circumstances test, but that's there's a cost to that. There's a cost to it for lawmaking, and there's a cost to it to law interpretation for the parties. So I think there's obviously of course cost for being formalist as well, but from my perspective, I think kind of bright line rules are generally better. Although I do take Melissa's point that it's interesting to see that in a patent case, this very well might come up as a bright line rule test, whereas for the last decade, Supreme Court has been basically wagging its fingers at the Federal Circuit and saying, stop with the bright line rules and sort of do kind of what everybody else does, which is standards as opposed to rules. One thing that I would I guess I'm not as worried, I suppose, as Steve might be about sort of the ripple effect on admin law. We do have administrative law judges, for example, in Social Security Administration. And yes, they do, a vast majority, if not almost the entirety of the work, but ultimately the decision rests with the commissioner. We do have ALJs in, ITC type proceedings, but ultimately the decision rests with the commission. And I don't think it follows that the director must personally evaluate every single case. But I think the point I think that some of the justices and I suppose Arthrex was making is that the fact that if director has the authority and just decides not to exercise it, that's the opportunity to point saying like, they're derelict or he or she is derelict in their duty. In either striking down a patent or upholding a patent or doing whatever, and there should be ramifications for it. Whereas today, director can't exercise that power, even if he does order a reconsideration, and because he might still be outvoted by 2 to 1. So that's my view. I actually do think bright line rules are better, at least in this situation, and I'm not overly worried about really kind of big earth-shattering consequences.
I'll just say one other thing on the bright line rule point, and especially in some ways, I think I agree with Steve that this is Steve Vladeck, that this is a recent development in the judicial arena, but I think it's largely a response to what I think is sort of a second wave of administrative law innovation in Congress. So creation of the administrative state was in the progressive and New Deal eras. But in the second half of the 20th century, especially in light after Watergate, there was this push to try to take more power away from the executive by creating a set of inferior officers, especially the independent counsels, and push power away from sort of traditional, relatively clear lines of authority. And I think this case is really sort of to the court. I think the court's going to look at this case and say it's not a patent case. This is Morrison versus Olson on steroids. This is a case where the government, the executive branch, can have its hands tied by inferior officers who can't be countermanded in any way by the attorney general or by the head of department or even by a cabinet secretary, as one of the justices said, even by the president. And I think one way to really get the sense of what that means is imagine we have inferior officers in the judicial branch of the government, like bankruptcy judges. And imagine if Congress said, well, if you have a decision by a bankruptcy judge, there can't be any review of that. But maybe the judicial panel that appointed them could fire them, or maybe they could grant rehearing, but there'd still have to be a majority of inferior officers on the new panel, new bankruptcy judges who are on the new panel. And somehow or another, maybe the Supreme Court could issue some sort of rule in its rulemaking powers, and somehow it could twist the arms of these bankruptcy judges to come out a different way. I think we would think that that's just radically inconsistent with how adjudication goes on. I think that's what the Chief Justice was getting at. If we're going to have adjudications in the executive branch, they have to look like adjudications that we expect elsewhere.
But John, I mean, can I push back on that great hypothetical? I mean, John, in that case, isn't the problem with having unreviewable decisions by bankruptcy judges that it violates Article 3, not that it violates the Appointments Clause?
I think it might violate both, but I think that you'd say that the problem is one of having inferior officers just lacking control. I agree that there might be a separate problem with inferior officer, with non-Article 3 judges having final authority. But I think also that just the idea of having people who are supposed to be inferior just be unreversible, except by, we can pressure them to get the right decision, I think is not the way we'd expect to see any kind of adjudication go in any other part of our government.
I would also add kind of a small point, perhaps not a small point, but it's just a very odd setup where, and again, it may be, as Melissa said, it's a legal fiction, but at the end of the day, patents are issued by a principal officer. They're signed by the director under director's seal, under seal of the patent office. It's somewhat odd to have an inferior officer or even a collection thereof overrule a considered decision of a principal officer. It's just, I don't know if there's a counterpart to that sort of system anywhere else in the federal government.
Sure. I mean, it happens all the time in the military justice system. And this is where I was going to go in response to John. I mean, the military justice system is within the executive branch. The judges are inferior officers who are, in other contexts, subject to the plenary control of the president because they're commissioned officers of the military, but whose decisions as judges are actually specifically insulated from that kind of unlawful influence because of the due process implications. And the courts have routinely upheld that. And so I guess, the notion that this is unprecedented and novel, I think is just something that I, at least through my very sort of one-sided lens of thinking about where you stand is a function of where you sit. And I spend so much time thinking about these issues through the specter of military justice and Edmund, right? In a context in which I think the analogy breaks down, because you have inferior officers sometimes striking down provisions of, for example, the rules for courts martial, which are promulgated by a principal officer, the Secretary of Defense. And the only review that is actually meaningfully available to overturn those decisions is by the appellate court within the executive branch and then the Supreme Court.
But Steve, I mean, the difference there is that those decisions are reviewable by the Court of Appeals for the Armed Forces, which is made up of executive officers appointed by the president and confirmed by the Senate. And so if there was a patent trial and appeal board and their decisions were appealable to another executive branch court made up of principal officers, it would be a very different case.
So Rob,
that actually is one of the remedies. That
Yeah,
actually is one of the remedies that the Congress has considered is considering creating a special board of sort of super APJs, let's say 3 or 4 of them, maybe 3 or 5 of them who would be appointed by the president and confirmed with the by the Senate, and they would act. They would then follow the military justice pattern.
But
I hope we do have time to turn to remedy, because that I think is really interesting.
Just really quickly, Rob's point, Rob, that's most cases. That's not all of them, right? I mean, there are cases that never get into the Court of Criminal Appeals because the sentences are too minor, because they don't come with, dismissal, et cetera. But the point is taken that in general, that mechanism is available.
Yes, let's jump to the remedies portion, because at least for Mark and the government attorney, the justice didn't seem that interested in remedies until Arthrex attorney argued, and then they were very interested in what the remedy should be. So just give a quick background. If the court determines that APJs are inferior officers, then there's the question of what do we do about that fact? And the Federal Circuit thought that they fixed it because they took away some of the provisions that made them difficult to fire. But I'd like to hear your thoughts about if that is sufficient, and if not, what should they do? Robert suggested in introducing the topic that they shouldn't do anything, let Congress fix it. Is that the right remedy, or is there something else that the court should do?
Well, I'll jump in here. I think saying that the court does nothing is not quite accurate. I think that the court should decide that this is unconstitutional, which I do think, counting up the justices, seems like what they're going to do. And then the appropriate thing to do is to vacate the results of the adjudication, vacate the IPR, and not try to come up with their own remedy, because I think there are at least 3 or 4 different proposed remedies that would require substantial rewriting of the statute. So, for example, one possible remedy was simply implying or adding onto the statute review by the director alone. It's not at all clear that Congress would want that, and you'd have to wonder why the director, why not the Secretary of Commerce? The director is subordinate to, the director is appointed by the president with the advice and consent of the Senate, but the director is a subordinate to the Secretary of Commerce. Why the director? Just because, that's a possibility. That is one possibility, but it's not at all clear that Congress wants. That's not at all clear that that would be politically feasible. Another possibility that Congress definitely was considering was have this super panel of the APJs, that there would be 3 or more who would be appointed by the president with the advice and consent of the Senate, and that they would be they would have an independent locus of power and kind of a sort of long-term check on changes in directors. The other possibility is to have all the APJs appointed by the president with the advice and consent of the Senate. Now, many people might think, well, that's 200 people or 200 more people. But there's 2 responses to that. One is historically the Congress did have the predecessors of these officers appointed by the president with the advice and consent of the Senate. And Steve Vladeck has very helpfully talked about the military here. And until only like 2 decades ago, an enormous number of military officers, down to like the lieutenant and colonel level, hundreds and hundreds of people were routinely confirmed by the Senate through mass lists. I mean, not every confirmation has to look like, Amy Coney Barrett's confirmation hearings, where you have a week of proceedings or longer. You can have them be very, very streamlined. So those are all possible remedies. I don't know why the court would think it has the right and the power to choose amongst them.
And I would just add in, historically at one point too, right, the predecessor to the director did have review over what was the predecessor of PTAB, right? They removed that, and I think it was 1927 because of concerns that it was going to overwhelm in volume. But, we even have precedent for director review. Steve, you're muted.
I am. I may be the one person here who actually wrote a brief defending the severability analysis of the Federal Circuit. So let me jump off of that particular limb. So I guess to me, I mean, first of all, I don't think there would be anything inappropriate about the court kicking this to Congress, about the court saying, we believe this is unconstitutional, but we're going to stay our decision for some period of time to allow Congress to fix it. That's exactly what the court did, of course, in Northern Pipeline, so many years ago with regard to the bankruptcy court system. I will say though that I mean I think part of what we're seeing is just how fundamentally the court's severability jurisprudence has shifted in the last decade, where it used to be that the court really saw its job simply as being a faithful agent of the legislature that wrote the statute. And now it's, I think, increasingly taking into concern policy considerations that it's not clear Congress was actually thinking about. I mean, if we actually look at what Congress was intending when it wrote the America Invents Act, I'm not sure that an inter partes review proceeding with judges who are at will, right, is necessarily any better than most of the other proposed remedies. And so I think the question is just, how do you modify IPR proceedings in a world in which you have to have, politically accountable, non-independent APJs running them? And I think that's a question for Congress in the first instance, but it's also, I mean, just to go back to something I said earlier, it's a question Congress is going to have to consider a lot, well beyond this case, because the number of administrative proceedings, I think, are now going to be called into question in a world in which we get an opinion that says, these characteristics define principal officers, period. I think is going to have consequences far beyond just what Congress does to IPR or to the PTAB in general.
So if I can jump in, I agree with John that the potential remedies that the courts can adopt are varied, and so I think that might very well counsel against the court adopting them, adopt any specific one, and counsel in favor of kicking the can down the road and letting Congress do it. But the more kind of, and I, full disclosure, I wrote a brief, as John had mentioned, for Cato, where we criticized the remedy that the Federal Circuit picked. And I must say that the more I thought about it, even after having submitted the brief, the weirder the Federal Circuit's remedy seemed, because having reread the opinion just in preparation for the oral argument and two panels that I was on today, including this one, it seems that the Federal Circuit really kind of was sold on the theory that Arthrex was pushing there and in the Supreme Court, that it's really about the unreviewability of APJs issued by a superior officer. So yeah, they recognize that yes, there's some control, and yes, the director can stack panels, and but really it's the lack of reviewability of the decision itself. And if that's the problem, it just seems a very odd solution to say, well, the decision will still be unreviewable, but then you can fire people later on. I mean, it just seems, it doesn't really respond to the problem, or to use a law professor word, it's just orthogonal to the problem. So counting votes, although always a risky proposition, I don't think there was anybody on the court who was interested in that solution. And I can see why. And the other reason, and this goes back to John's opening statement, is that kind of making, and also I guess teed off what Steve was just saying, why Congress may not have wanted at-will APJs, is that having APJs that are purely at will and can be pressured politically, basically, in theory, you can have the president call them up and say, do this or you're fired, may create a mockery of an adjudicatory process. Part of the, generally speaking, when we do have executive branch adjudication, we have some sort of insulation from political pressure. And so ultimately, it's kind of this balance between the insulation from political pressure on one hand, but proper, line of responsibility on the other hand. And so maybe a solution like this kind of the super APJ panel may kind of, straddle that fence correctly.
If I can also just pick up on John's thought from earlier, if anything, he's guilty of understatement. He mentioned that there were 3 or 4 alternatives here. By our count, when you tally up all the different potential fixes that had been proposed across the 31 amicus briefs, it's actually at least 10 different options that have been proposed to the court. And in those kind of circumstances, deciding whether the court should try and pick one or defer to Congress, I do think it's kind of helpful to go back to first principles and what the severability doctrine rests on. Justice Kavanaugh's plurality decision in the robocall case from last year was pretty clear on this, that in his view, at least, severability analysis is motivated by a desire to avoid judicial policymaking and the fear that if courts start doing more than severing a statute, they're really taking on a legislative function that is better handled by Congress. The problem here, though, when you have 10 different solutions and you can really just only speculate about what Congress would want, and then on top of that, not only options to choose from, but like the Federal Circuit, where you hold a particular provision invalid only as applied to some circumstances and not others, it really seems that you're undermining rather than furthering that underlying purpose of avoiding judicial policymaking, because it is a policy decision whether you elevate these folks to the status of principal officers or go the other direction and subordinate them and make them subject to the director's review. Those are policy choices, not judicial choices. And so, in this kind of case, just the underlying rationale for the severability preference that the court has acknowledged really just cuts the other way.
I'll just say, I think Rob's summary of Justice Kavanaugh's plurality opinion, I think it illustrates exactly the way I think that the court's severability doctrine has drifted, where, there was a time where I think the court accepted that all severability requires some modicum of judicial policymaking, because you have to have, unless you strike down the entire statute, you have to end up with a statute that's different from the one Congress enacted. And the question is, how is it going to be different? That's, unless the court's never going to make that choice, we're going to have a severability doctrine. The notion that we can somehow sort of decide which rewrites of the statute are policymaking and which ones are compelled by constitutional analysis, I think has always been a bit of a fool's errand. And so, the larger point, which I suspect we all agree on, is there's a pretty significant severability opinion that's going to come down before this one. And however that comes out, I think that's probably going to inform to some degree how the court approaches this. I'll just say that to me, what always appealed to me, and this is sort of in brief response to Greg, about the Federal Circuit panel's analysis, was that it seemed to do the least violence. As I say, it seemed to do the most to leave intact the IPR process that Congress meant to create in 2011. That may not be sufficient. And again, I for one would prefer Congress to just readdress this from the get-go. But from the perspective of, the court's job is to do the least amount of violence to the statute that's left over once you take away the unconstitutional part. That's what struck me about Judge Moore's opinion. That was the one part of Judge Moore's opinion that struck me.
But Steve, and I think that's right. I think it does preserve IPR, perhaps sort of in a form that Congress may have wanted. But like I said, the solution has to address the problem. And so unlike, for example, in CFPB case, right, in Sailor Law, where the problem was the lack of authority, the lack of authority to the president, the lack of ability of president to control the individual. Here is not so much lack of control, which everybody can see that there's some level of control. It's the lack of review of decisions. And so it's kind of, I think Judge Moore, what she did, she took kind of a Sailor Law solution and perhaps PCAOB solution and imported like into slightly different problem. And I don't think they just work together, even though the outcome is kind of, you're right, doing the least violence to the statute.
I do think that one way, a very traditional way to think about this case is just to think about it as a case or controversy. And Arthrex has argued that this adjudication was unconstitutional. And the answer that seems to be, at least among the scholars that reading the oral argument, it looks like the court's going that way. They could just say that this is unconstitutional and therefore this adjudication is reversed. And to go on further beyond it and say, well, if you cut this piece of the statute, or you did this to the statute, or you did this other thing, that would solve the problem. I mean, that really is going to a very non-traditional view of the judicial function. Robert's clients have been adversely affected by an adjudication, an administrative adjudication. They've argued that it was unconstitutional. If the court decides they're right, the answer is that that gets reversed. And it's sort of coming up with other remedies like, do this other thing, don't do this other thing, fire the APJs, or give you the right to fire the APJs. I mean, all that seems very non-traditional to me. And I think the way of judicial restraint is just to simply say, this adjudication was unconstitutional.
But then I guess, John, how would that work in practice? Because then the very next party to lose in the IPR goes to the Federal Circuit and challenges that adjudication. The Federal Circuit would have to decide anew, right? And so, I mean, I guess that's it.
Well, that would be unconstitutional too, until Congress changes it, or until the executive branch says, you know what, because this is unconstitutional, we have to read Section 6 as non-existent and that there's a director power to review this, which I think if you imagined an administrative official saying, though the statute gives me no power to do this, I can do this because I get power directly from the Constitution to do it. That would be kind of unusual. But
well, I'm not sure how you could get. I guess I would have real problems with the Article 2 argument in that context. But leaving that aside for the moment, I mean,
I would too.
The relevant point at that point, though, is that no holding on severability therefore becomes a de facto holding on severability.
It becomes that the agency cannot function until either Congress finds a solution or the agency comes up with a solution and says, we've read the statutes in light of your opinion, and we think that we've cut off the pieces and we've done this new adjudication and we have statutory authority for doing it.
And that's why, although I don't think it is right or necessary, I think one possibility for the court is to pull a Northern Pipeline, which is to say it's unconstitutional. We're going to stay the effect of this decision for 6 months. Congress and or the PTO, you've got 6 months to figure this out.
Yeah, I just don't, staying the effectiveness. I mean, such a thing, they're not going to stay the reversal of the order that this patent is invalid. That should issue immediately. The Arthrex plaintiffs here or petitioners in the court have shown that if the majority agrees that it's unconstitutional, then to stay that seems kind of odd and really beyond the traditional judicial function. You're right that Northern Pipeline did it in the second half of the 20th century. But that's part of what I think this court is rebelling against, that novel approach to both separation of powers and judicial function.
I'll just say novelty begets novelty.
Novelty goes back to tradition, I would say, but you say tomato, I'll say tomato.
All right, we have a question from the audience. I know John has a class right at 6 o'clock, so he might have to slip out. Thanks for joining us if you have to leave. And the question from Alexander, he says, the justices seem concerned about assuming what Congress would want in determining a remedy. Yet just 2 years ago, Justice Thomas assumed that Congress did not intend to eliminate secret sale jurisprudence, despite Congress's explicit change of language of 35 U.S.C. 102 to provide the so-called catch-all phrase. Is there a way to reconcile these seemingly irreconcilable positions held by Justice Thomas and presumably other formalists on the court?
Well, I will make this my final word, and then people can crash on my argument. This will be my way of segueing out. That wasn't an issue of remedy. That was just a straight up issue of law, and it didn't involve the issue of remedy. That was just an issue of statutory interpretation as to whether the addition of one phrase modified traditional meaning of other phrases that were in the statute. And the court, following relatively standard canons of statutory construction, said no, it did not modify prior attached meanings to well-defined phrase that Congress was reenacting in the same statute. So I think that's an issue not of remedy, it's just an issue of what the statute says. So I think that's the answer there. But I've enjoyed the panel. I have to go teach a class, so thank you.
I wish John could have stayed, but he told us before he would leave. But I do wonder if he had the same read, because when I was counting noses, which is again always a dicey proposition, I was actually convinced that Justice Thomas is an affirmance. I thought that he was hard to predict, and if anything, I was actually my very very tentative prediction was that it's a 5-4 decision with Justice Thomas in dissent, and the majority being the Chief Justices Gorsuch, Kavanaugh, Barrett, and who am I missing? And I'm right, Chief
Alito,
right now, and Justice Alito. I wasn't convinced, given the tenor of the questions, that Justice Thomas is on board with Arthrex's argument. But what do I know?
All right, this is a good time. We have 5 minutes left. For those who want to, and obviously there's no need to, any predictions on what will happen when an opinion issues? Greg gave us his.
Well, I just gave you mine, so yes.
Sorry, Melissa, go ahead.
Yeah, no, I mean, I thought, they were leaning with how formalistic their questions were, that it's going to be, I thought it'd be 6-3 principal officers. I'm not sure about remedy. I think they did not like what the Federal Circuit did, but I'm not sure.
Yeah, I guess I will be very surprised if Justice Thomas is a dissenter in a formalist appointments clause case. Although I guess anything can happen. But I'm with Melissa. I think, unfortunately, because I think it's a problematic precedent. It'll be 6-3 on the appointments clause, and on severability, I think they're gonna, they have fractured a lot, Jonas, on severability in cases in recent years, and I don't see why. This strikes me as another, unless they can find some narrow consensus, or unless they can all agree to some kind of weird, remand, de facto remand to Congress, which, as John points out, is not common. I mean, yes, I have the Northern Pipeline example, but that's the example. Yeah, I think it's very possible to get a couple of different severability holdings, which will be really weird because then there might not even be a majority rationale on severability.
Hey, Steve, can I ask you a quick question? Like, what's the value of staying the decision, right? So if they just simply say, look, this is unconstitutional as of today, and let Congress figure it out, if you stay, what does that mean? Like, in your view, will PTAB actually just continue with adjudications in the hopes that it will somehow get ratified, backdate? I don't understand the value of the stay.
So I guess, to me, the value of the stay is because then you don't have judgments that vest. That was at least the issue in the bankruptcy court context, where you have proceedings that go final, and therefore you trigger all of the difficult rules about reopening proceedings that are final, et cetera, once you figure out what the new regime is going to be. So, Greg, it's a mess no matter how you slice it. I just think that this would be a context in which, instead of rewriting the statute, the court would for once be putting the weight on Congress to rewrite the statute by a date certain, which I think is in some respects much more respectful of the legislative power than many of the court's more recent forays into severability.
Then, yeah, the last thing I just wanted to say was, I also think it's interesting to think of what ramifications this would have in administrative law, right? So if you look at just straight up formal adjudication, it does have typically director review or agency head review, right? For these, what admin law call these type B adjudications, which are very formal, like typically have a hearing, but in the statute, but don't require APA, arguably not APA formal adjudication. It still is quite common to have director agency head review, but there are a number, right, of examples that you can see, like the Civilian Board of Contract Appeals or the Board of Veteran Appeals, right, that are more similar. So it's sort of interesting to think about if that's really going to be the touchstone. You have to have, agency head review. Where would we also see concerns about other principal officers, right, that are unconstitutional?
Yeah, so on that point, just to close out, is this an admin case or is it a patent law case? There was some discussion of this. Justice Kagan had a question which it appeared maybe she was confused or she didn't understand patent law, or maybe she was just exasperated by patent law. And it's a little bit unclear to me still about whether this is just a patent law issue or whether it's a broad administrative issue that infects lots of different areas. I don't know if we have the answer to that, but does anyone have any thoughts on that?
I'm really curious what Rob and Mark think about this, because they're much more in the trenches than I am. I guess I come at this as someone who came into this case not as a patent person, right, and wrote an amicus brief not from the perspective of patent law, but from the perspective of sort of outside considerations and con law. I guess to me, the more this is an administrative law case, the more that favors Rob's position over Mark's, because it suggests that this is about standard administrative law principles and that there's nothing particularly special about the patent system or the PTAB that would justify treating APJs as inferior officers. Whereas I think the strongest arguments in favor of viewing the APJs as inferior officers are all about the idiosyncrasies of the patent system and the extent to which IPR is actually not initial review, it's second review, it's review of a decision by a patent examiner, right? That this is not sort of, general civil adjudication between third parties with no predicate. And so, to me, the more the court was talking about general principles today and the less it was talking about the specifics of the patent system, I think the more that was discounting what to me are the strongest arguments in favor of finding that APJs are inferior officers.
Mark or Rob, you want to respond?
Well, my observation on that is it is not the case. It cannot be the case, and it was not the case, that Hamilton and Madison and crew sat around and thought up the Administrative Procedure Act in 1789. Yet that is one way to view the position being pitched here, that if you have administrative adjudicatory type proceedings, and I say that advisedly because these are not adjudications, right? They are adjudicatory type proceedings. They must follow a particular method, including agency or commission head review. To my mind, that has the founders rolling over in the grave. This notion that the formalists find any support for this in history strikes me as crazy, because there is no tradition before 1946 of uniform agency head review. It is a convenient default mechanism for modern administrative true adjudications. But again, the Patent Office is not true adjudications and has never been. So, we've got square pegs and round holes all over the place here. And the challenge for the court, and the reason the opinion may come out however it comes out, and it's bad juju, I'm not going to make a prediction. It may very well be quite fractured in rationale, right? Because it depends what lens you look at this case through, what end of the tunnel you come out of. And I think that's more true here than in many of their cases.
Jonas, I'll just add, I mean, both in the patent context specifically and the admin law context more generally, the appointments clause does give Congress a lot of flexibility. Like, there are a lot of ways to design agencies, but at the same time, it also does provide some outer boundaries beyond which Congress cannot go, and setting up a system where you have administrative judges adjudicating disputes worth like billions of dollars that shape the course of innovation across industries. And yet Congress has completely eliminated the ability of a principal officer to review those decisions. It's just anomalous. It's historically anomalous in terms of what the PTO has done over the years, and it's historically anomalous in terms of what administrative law generally has done. And so, I do think that's the uneasiness we were seeing on the court today. At the same time, the fact that there are a lot of ways Congress can do things within those constitutional bounds really informs what the court may want to do on the remedy here, which is, why should the court, as opposed to Congress, be the one picking among those many options? So those principles which cut across both patent law and admin law inform both the constitutional question and the remedy question.
Great. So I think my son was the sign that we're done. So I want to thank all of our panelists today, including John, who had to leave early. Thank you very much. So hopefully this has been informational. These are the best people to get the information from, and they argued the case today. So thank you very much for joining us after a long day at the court. So I'll see everyone later at the next event. Thanks.